Welcome to the iBreeders podcast on SHAs or Shareholder Agreements. This is Abhyudaya from Team iBreeders. In this podcast, we are going to discuss what SHAs are, why you should care to negotiate them, and 4 issues that you can negotiate in SHAs. An SHA or a Shareholders Agreement is a legal document which governs the terms of an investment transaction. When an investor agrees to fund a startup, he enters into a share subscription and a shareholders agreement, commonly referred to as the SHA, which includes all the terms of the investment, such as the shares the investor will be issued, what dividends he will be entitled to, and other rights in the company that the investor will get. Why should entrepreneurs or their advisors care about an SHA? There are 2 reasons why negotiating an SHA is important. Firstly, while you may have secured funding, the terms on which you obtain the funding are very important. Often entrepreneurs realize too late, at a stage when they cannot reverse the transaction, that the terms that they've secured the funding on are very onerous or burdensome for them. For example, an entrepreneur would not want to give disproportionate rights to a VC or give rights which make day-to-day operations of a company difficult or uncertain. Secondly, if it's the first round of investment, this round is going to be critical because it's going to set the base standard for the rights that investors in subsequent rounds, such as Series B and Series C, will require. If you give away too much in the first round itself, investors in Series B or Series C rounds will require that as a minimum. Therefore, it is very important for entrepreneurs to be able to negotiate their SHA. At the same time, lawyers, managers, and advisors to entrepreneurs can add significant value if they can assist in the stages of negotiation of SHAs. What are the 4 key areas that can be negotiated in an SHA? First, personal liability of the founders. Often, investors circulate SHA drafts which require founders to be personally liable for various events related to the investment transaction. Now, personal liability for the founders can add disproportionate risk. Usually, it can be negotiated and limited to the liability of the company in case anything goes wrong with the investment transaction, so that the founders' personal assets are protected. Secondly, the right of the investors to be present on the board of directors of the company and the decisions for which their consent is required is something that can be negotiated by entrepreneurs. Third, the rights to receive information pertaining to the operations of the company, financial information, business plans, etc., can be negotiated so that it is not too onerous or burdensome for the entrepreneur. Fourth, an SHA also contains certain exit-related rights, which require a company to take certain steps so that the investor is able to make a profitable exit from the company within his investment horizon, which is usually 3 to 5 years if the investor is a financial investor such as a venture capitalist or a private equity investor. Again, the terms of these exit rights can be negotiated. At the end of the day, you should note that an investor merely wants security that his investment will be protected and some assurance that he will be able to exit profitably from the company. At the same time, an entrepreneur wants to be able to run the day-to-day operations with some level of freedom and flexibility. These objectives are not necessarily conflicting, and negotiation can actually help both parties in protecting their commercial interest. In fact, you will be surprised to know how much you will be able to negotiate an SHA if you simply tried to. That's all for this introductory podcast on SHAs. We'll be back soon with more podcasts. Thanks.